to Jason and Philip for giving me this opportunity to speak at this event. It's a topic that's close to my heart, as you'll soon find, that I've become quite animated about this topic. Maybe the program is slightly euphemistic, because as you'll see, the real topic of my conversation is the dysfunctional custodianship of intellectual property law by the government. And you'll soon find out why I use such strong words. Like I said, I was approached by Jason to speak about this topic. Or not about the topic. He said, what do you want to speak about? And I said, well, about this concern I have about how legislation looks in South Africa at the moment and how proposed legislation looks. And these factors suggest that government's handling of intellectual property law and related subject matter is dysfunctional. And since then, and I think that was just over a month ago or something when Jason asked me to speak, 6 weeks maybe, the Department of Trade and Industry, DTI, published the Copyright Amendment Bill. And in doing so, so that's what I'll call the 2017 bill, in doing so they essentially wrote my speech. Because this bill again amply demonstrates why the government's custodianship, especially the DTI, is so problematic, and why it's a source of concern to those of us who seek to promote the integrity and quality of South African intellectual property law. The language I'll be using to raise these concerns and my opinions will be strong. I do not make any apologies for the strong language. There is no way in which these matters can be sugarcoated. The reason for this is twofold. Why I feel so strongly, and I have to put the argument so strongly. At the chair of intellectual property, not only myself but my predecessor, we made repeated attempts to indicate to DTI why its proposals, and indeed past legislation like the Intellectual Property Law Amendment Act of 2013, were so misguided. But of course there's no indication of any sign of improvement. We're constantly faced with situations where the DTI makes proposals, threaten to do more harm than good, and the pleas for good sense to prevail seems to fall on deaf ears. The second reason is the manner in which the DTI goes about its business leaves much to be desired. It develops legislation seemingly without the input of key stakeholders and people who know the field, and without proper warning or prior consultation, it just drops legislation like it did with the Copyright Amendment Bill. So it doesn't give people, interested parties, an adequate opportunity to formulate and give their input into the process, voice their concerns about the implications and the consequences of some of these ideas. And like I said, the legislation, I think, was published on the 16th of last month, and we have until the 17th of this month to give comments. So we have to drop everything. Law firms, stakeholders, we just have to drop everything to start writing comments. And what's worse is that the legislation is so badly drafted, you have to spend an inordinate amount of time writing up comments, because the drafting is done poorly. There's no way to, like I say, sugarcoat this. It is bad drafting. it displays a lack of familiarity even with the existing legislation. So this is what we're faced with. This is the output that we get from the DTI. As I said, I've been busy now for more than a week drafting comments. My comments already exceed 11,000 words, and I'm not done, right? And it's shocking to think that there are individuals at DTI or wherever who are paid probably not insubstantial amounts of money, who produce drafting of this poor quality and propose legislation of this poor quality. So this is service delivery failure. And this is my service delivery protest. This type of modus operandi, I'd suggest, is even more problematic in the sense that I think this should leave this type of legislation open to constitutional challenge, because it flagrantly disregards constitutionally enshrined principles and merely goes ahead with some veneer of procedural formality. It's done by people who clearly don't know what they're doing. There's no other way to put it. And you can't pass legislation in that manner. As I said, the legislation is substandard. And when I say that, I am in no way suggesting that only legislation that conforms with my view of the world will pass muster. That's certainly not what I'm saying. I'm also not pretending that IP is not a politicized matter. While I may not agree with a particular substantive provision or idea, I may be sort of resignatory if the provision was at least drafted with some level of competency that you could understand how it works within a framework. But we can't even give it that credit. And of course this has real consequences, because even your well-intentioned provisions become ineffective and become a nonsense if it's not properly drafted. And of course at this stage you think, this guy, what the hell? And you probably consider my criticisms to be unduly harsh and maybe even unfair. But let's look at some of the provisions, and I'll ask you to make your judgment at the end. I think they will amply demonstrate how ill-conceived the current bill is. So for those of you who are not copyright experts, and no one should be, let's look at copyright law. Let me just see. So there we go. So that's just a definition broadly of what copyright law does. It basically creates a framework by which property rights are given to creators of literary works and musical works and artistic works and that type of thing. Right? So, and there's a good economic argument for why this type of protection is extended to works of this nature. But we don't need to go into that. But let's just speak about two basic concepts. And this is the easy stuff. You'd expect any draftsperson to get at least this right. So, a copyright work generally is created by an author. That's the technical term we use. Of course, in layman's speak, there might be an artist, or you'd speak about a writer. But in copyright law, in terms of the Copyright Act, there's an author, right, in respect of the various types of work. And then there's the owner of the copyright. Now, the owner and the author need not be the same person. So the default rule is that the author is the owner. That's in section 21 of the Act. But like I say, that need not be the case. So for example, typically there's an exception in section 21 whereby if the work is made in the scope and course of employment, the employer becomes the owner of the copyright, but the employee was the author, right? And while ownership of copyright may change, so copyright can be transferred or what we call assigned, so ownership of copyright can change multiple times, the author will always remain the author because that's the person who created the work. That's a basic concept, that the author remains the author. The concept of the author is immutable. Once the work's created, you have your author. But like I say, ownership may change. The author, if they were the original owner of the copyright, they may have assigned or transferred the copyright to, for example, a publishing house, who becomes then the copyright owner. It's property. And failing to appreciate this basic distinction right at the core of copyright raises fundamental concerns and displays a lack of knowledge of copyright. I always say to my students, it's very easy to distinguish who has studied intellectual property law and who hasn't, even amongst, qualified, admitted lawyers or solicitors. Intellectual property is rather sort of an esoteric area, and you'll quickly pick up from the terminology of the person whether they know what they're talking about or not. So you probably, some of you of course are older than my students, but I always tell my students, you've probably sat in a pub and when people get drunk they think they're getting clever, and your friend comes, says something, and he says, oh, I want to copyright that idea. And I say to them, when you do this course, you know your friend's an idiot because there's no copyright in ideas. It's that type of thing. You know whether somebody has studied intellectual property law or not. So let's look at a provision which, quite frankly, I don't feel strongly about. I don't think we should have in South Africa. But, I'm fairly agnostic about this provision. But look how ineffectively and impractically it's drafted. And then I'll get on to some of the real concerns about deprivation of property. But here's something that I couldn't care less about, to be honest. I don't think it should be there, but let's use it as an example. This is the so-called resale royalty right. So for those of you who are unfamiliar with this concept, the resale royalty right gives the author of an artistic work the right to receive a percentage of the subsequent sales of that artwork. So typically your Picassos and that type of thing. So now they go for mega millions, and the feeling is that Picasso or his estate should get a percentage of that. That's essentially what this right entitles it. I think it's a nonsense, but a lot of countries, the European Union has a directive on this, and so it's part of European law. We can debate about why I say it's nonsense if you want to. But, like I say, I'm agnostic whether you give this right to the author. So, what does the title of the section say? It speaks about, and I didn't put the title, it says resale of royalty rights. It's not resale of royalty rights. You're in trouble when you can't even get the title of the section right. Okay, so you might think, oh, it's a little typo, why is it getting so exercised? Well, look at subsection 1. They say that the right will be triggered following the first transfer by the user of the artistic work. Now, anybody schooled in copyright law would ask, who's the user? This is not a concept that should be using here. Like I say, it's an author's right. So you didn't even use the correct term. You've now created uncertainty. Who's the user of this thing? And of course, there's ample evidence to suggest that that's not a mistake either. Because if you go to subsection 3, of the Act, it gets even more bizarre. They speak about the right to royalties being exercisable by any one of those people. Clearly, this person doesn't know what they're doing. Right? That's putting it plain. And this is not an isolated incident in the bill. The bill is replete with this type of shotgun approach, where they just list phrases like user, performer, owner, producer, author. In several cases. In other cases, they don't even identify the relevant party that should be having the rights. And of course, if you're in a law firm and a candidate attorney brings you this type of thing, that person's career is not going to be of any longevity in that firm. So why should we accept this from the DTI? And allow people to probably, like I say, not get insubstantial amounts to produce this type of nonsense. This sounds like a cover your arse approach, because you don't know what you're talking about. But I'm sorry to say, you're not covering anything. You're just making yourself look like something you'd not want to be compared with. Right? And like I say, this is problematic. It brings about uncertainty. You don't know what this right is meant to do or achieve. And this is not the low point of this particular provision or concept. Lo and behold, Section 9F2 speaks about the transfer of authorship. As I previously mentioned, this is a concept hitherto unknown in copyright law. You don't transfer authorship. So when you write nonsense like this, don't expect me to go easy on you. Like I say, if this was an article clerk bringing this nonsense to me, that's the end of the road. There's no, I can't mince my words with an article clerk like that, because you don't know what you're talking about. Right, so let's look at some of the practical provisions here. Like I say, this is a concept which, this resale royalty right, which exists in other legislation. You could have copied it from other legislation, and you didn't even manage to do that competently. So, elsewhere in the world, this right is confined to the original artistic work. There's no mention that this right is confined only to the original work. There's no indication that it's confined to the professional art market, sort of sales through galleries, etc. How are you going to enforce this right? You know, in other jurisdictions, they said, let's be sensible about this right. Like I say, I don't think it should exist, but if we are to extend it, it sort of sails through institutions, galleries and that type of thing, auction houses. This just shows a lack of practical nous. It's unworkable. There's no threshold amount. In other countries, in Europe, I think it's sales over 2,000 euros or something like that, where this right kicks in. So now any little sale, irrespective of whether it actually turned a profit for the person, is now subject to this royalty. The Act claims to essentially have extraterritorial effect. So if the sale takes place in a jurisdiction where this right doesn't apply, I don't know how they're going to do this. Right? So it's just this type of lack of thinking through the process. If things can't get worse, I'm sorry to say it does, because they speak about, now in the Act, if you look at Section 1 of the Act, the Act says you can have a work of joint authorship. So the concept of joint authorship, where you have two authors of the same work, exists in our law. They use the expression linked with. Somebody linked with an artwork. We know you linked with an artwork, entitling you to a portion of the royalty. No, of course, explanation for that, because it's a nonsense, right? The person doesn't know the Act, that you could have joint authors. And that's the terminology you should be using. And of course, like I say, this is how badly you get it wrong, even if your provision is well-intentioned. So this right says, as currently drafted, that it's transferable to your heirs by way of testamentary disposition, so by a will. Now, if you are sentimental and you want to protect the poor artist who never maybe saw a profit in his or her lifetime, and maybe now their works are going for mega millions, there's probably a good chance that that artist probably died intestate, i.e. didn't even have a will. So that artist's estate doesn't benefit from this. That is how badly you get it wrong, right? Because you don't only need to know copyright law, you should know the law of succession as well when you draft something like that. And clearly you don't know either. So this is what I mean, and this is what we're faced with. So I cannot be sympathetic to legislation of this nature. I have to call it as I see it. So fair dealing, and of course, here we're really talking about deprivation of property rights. Again, the legislation makes it unclear, if I can use that phraseology, makes it unclear what our position is regarding fair dealing or fair use. So in South Africa, we have followed an essentially British approach to date. So we have a concept of fair dealing exceptions. So these are specific listed exceptions which won't amount to copyright infringement. So it's a closed list of types of activity. And then you have this sort of American approach, which is fair use. It's more open-ended. They give you a list of factors by which a particular type of conduct can be assessed to whether it's fair or not to use it. So these are the broad two schools of approach to this concept of exceptions to copyright ownership. But of course, ours, or the proposed section, is neither fish nor fowl. You don't know if we're dealing with fair use or fair dealing. You don't know what your point of departure is. And of course, you could have a sensible hybrid approach. You say, well, we want to go to the American approach, the fair use, a more open-ended approach, but here's a list of things which are prima facie fair use. Then you know exactly where you're standing. You know, we are now in the realm of fair use, but now we have sort of listed things which are prima facie permissible. But the section fails to clarify that. They just use the terms fair use and fair dealing. And like I say, you need to know what your point of departure is. And the person who drafted this doesn't even know the current structure of the Act. So how the Act currently works is that, as I said to you, there are various types of copyright works. So literary works, artistic works, cinematograph films, published editions, etc. So in section 12 of the Act, which deals with literary works, and I think musical works, it sets out the most sort of comprehensive list of exceptions. And then there are following sections which cross-refer to section 12 and say, well, in respect of a sound recording, these subsections of 12 are applicable to sound recordings. That is the structure of the Act. What they've done now is basically repealed the section, for example, on sound recordings, So if you don't have that section to tell you what's permissible or not, you have only one general section. So for example, under the new Act, it will be quite permissible for anybody to make private copies of DVDs and CDs and music. So basically the Act, or the bill, has created a private piracy charter. That's what it's done. Because the person didn't see this issue of cross-referencing. And of course, for others, the issue of education and teaching, that broad subsection or exception is a source of concern. Now, the teaching exception already exists in our Act. In fact, the only regulations that were published under the 78 Act relate to teaching. And Section 13, under which these regulations were made, have not been repealed under this proposed bill. And they don't even say that the regulations will be repealed. So if there was an explicit link between this teaching and the current regulation, I could probably live with it. Because the main purpose of the teaching exception is for purposes of illustrative use of a copyright work in the classroom. And no one can object to that. I think even your staunchest defender of property rights would say that's eminently reasonable, right? But you suspect that what's now proposed is a much wider teaching exception. And that's certainly the case with this education exception. This is unacceptably broad. You know, you can be critical of IP. I encourage debates about IP. But those who are critical of IP, I always say they don't debate from a position of information and knowledge. They're good at making emotive claims about the harmful effects of IP, but they don't really substantiate it with evidence. And I think in our context in South Africa, in education, there is no evidence, as far as I'm concerned, that IP is an impediment to education. If government wants to provide cheap textbooks, there's nothing in law that says that they can't do that. They're quite at liberty to commission authors to write books for them and print it to their heart's content. There's nothing in copyright law, intellectual property law that stops you from doing that. It will be owned by the government, and they can put it into the public domain if they wish. Why not? The same with translations. You know, if the government wants a translation of a particular work in a particular language, go speak to the copyright owner. Which copyright owner or publisher wouldn't want a government contract with the ability to sell thousands or if not hundreds of thousands of books? They'll be biting government's hand off for that type of contract at probably quite preferential rates. The publishing industry is hardly a monopoly in South Africa. So why do you need to go ride roughshod over property rights? Of course, the reality is that IP is used as a scapegoat or political football for government failure. So we've had the well-publicized incidents of textbook non-delivery. That's got nothing to do with IP. That's government failure. It's got nothing to do with property rights. It's non-delivery of services. So don't deflect from your own failures by riding roughshod over property rights. But there's this wide right given to institutions. In Section 13B of the Act, I don't know if it's, yeah, Section 13B in education. which basically gives an institution like a university the right to freely copy a textbook and make it available to students. Just disregard property rights. But let's look at the basis upon why you would want to do that according to the bill. The bill says that you do that because the particular textbook, and I'm paraphrasing it here obviously, was not priced reasonably in relation to the price normally charged in the country for comparable works. Now, it probably never occurred to the drafter of this provision that if there really was a comparable work at a reasonable price, there should be no reason for you to want to use this book. Use the book that you're comparing it with and that is at a reasonable price. Why ride roughshod over property rights? But this is the warped logic, this sort of Orwellian nonsense you're dealing with, right? So, I mean, as you can see, I can get quite animated about this, but when you have to read nonsense like this, it is a cause for immense irritation when you've had to write a week of comments on nonsense like this, right? And of course, our comments, incidentally, once we submit it to DTI, is available on our website. So we make all our comments available, as we did in the past. So, but even at a philosophical level, there's a problem here. And I think it's something that touches on what Philip said earlier. So you have this notion that what the government is trying to do is promote education. That it wants to increase intellectual activity, that to get us to that higher stage of production. But of course, through provisions like 13B, what it does, it actually devalues exactly what it seeks to promote. It, in a sense, tells people why learn, why enrich yourselves, why create new works, because we will just take it away. So it's troubling at a philosophical level as well, if you really look at it. Right? There's no incentive to create them. You say you want to sort of invest in human capital and all that, but of course your way about the way you go about this is to suggest that that is not property, that that is not valuable, that there's no incentive for you to do that. That's really what you're saying. So, and again, I mean, like I said, this type of warped or skewed thinking, the basis of compensating an owner whose works, because there's now a broad translation license and reproduction license schedule, the basis on which you reward a copyright owner whose works you've just reproduced are interesting. They say that that owner is entitled to compensation, and of course they don't speak about owner in the section. They speak about, again, users, performers, producers, all that nonsense, because they couldn't even figure out that it's the owner they should be speaking about. Will be compensated in a manner which is consistent with the royalties that would be paid in the case of a freely negotiated license. So if that's the basis on which you're going to compensate them, why not just negotiate a license? Why ignore the property rights then? If you're claiming to pay them on that basis, then enter into a contract and get the matter sorted. You don't need this type of provision. And this is the, like I say, symptomatic of what's going on here. The only way, like I say, a commercial publisher will refuse a government contract on something like a translation is because they're concerned maybe about the quality of the translation. Because translating a literary work is not a mechanical process. You have to get the nuances right. The idioms in a particular language may not be sort of easily transposable into another language. Those may be the concerns. But if you're going to pay them the going rate, no publisher is going to spurn that offer. They're going to say, sure. So you don't need this type of provision if that's the basis on which you're compensating people. Strangely, the one ground on which the government can't just translate your work without your prior consent is when they can't locate the owner. Now that's warped logic again. Because you think the very time you need to proceed without permission is when you can't find the owner. And that's what the Act specifically excludes. So you see, this is the type of idiocy. Sorry, I have to use these words. Idiocy you're dealing with. Right? It just doesn't make sense. And like I say, when you have to write on this thing for 7 days, you become like me. Right? Hot under the collar. There's this broad exception for underserved populations. Underserved by whom? The government? Who underserved these people that you can ride roughshod over other people's property rights? So, grandiose statements, playing to the gallery, but in effect doing more harm to the populace and to the copyright owners. That's the reality of this bill. And of course, if the person who drafted this actually just looked at the current Act, which does provide for compulsory licensing, which is actually of broader effect than merely just translations, they should have realized that maybe we should have retained this right, which incidentally they're repealing. But you see, they're playing to the gallery by speaking about education and translations. But if there's really a need for a work to be reproduced in South Africa, we have a provision, which incidentally has only been used once in South Africa's history, in the 1970s. Okay? So that is the reality of the situation. You have a provision. If you really need to use or override property rights, you have the provision. But you seemingly need sort of more sledgehammer tactics to cause a concern for the publishing industry and everybody else. So there are other noteworthy concerns if you think that that's it. 7 days or 10 days of writing produces a lot more than that. But I've just listed them up there. There's the Intellectual Property Laws Amendment Act, which there's no proposal to repeal that. It's fundamentally misconceived. But DTI plods along, wants to bring this into effect, despite damning condemnation from all corners about the fact that it's doing harm to the integrity and structure of our intellectual property laws. And incidentally, DTI doesn't quite sit around the same fire on this issue with DST, the Department of Science and Technology. I think DST still sensibly would like to have sui generis legislation, meaning specific legislation dealing with indigenous knowledge, which is the right way to go. Right? So there's a bit of a turf war going on there. But you know, DTI wants to stay the course and win that missing contest. So that's what we're dealing with. I haven't even commented on the Performers Protection Act, which apparently is being amended. There's a bill out there as well. Like I say, I've been so busy writing the comments on the Copyright Act, I can only think about the mess up of the proposed amendments to the Performance Protection Act. If you look at it more detailed, and like I say, I don't want to bore you because some of this stuff can be quite technical, but the protection in the Copyright Act on literary works in South Africa currently really protects databases as well. So a collection of tables and compilations in terms of the Act would be protected as a database. We don't, as in Europe, have specific database protection. Right? So in a sense, the database is only protected as a copyright work. This proposal now essentially says that really a compilation will only be protected if it is the author's own intellectual creation. Now that is not an expression that's known in South African law. It's well known in Europe. If we want to adopt that standard, let's speak about it. I have no objection in principle, like I say, but don't introduce it specifically now in relation to compilations. What is the knock-on effect on other works? Because what we have traditionally followed is the old British concept of originality in South Africa, which is what we call the sweat of the brow approach. So if you've expended effort in the creation of your work, you get copyright protection, right? We haven't used the standard of author's own intellectual creation. Like I say, I'm happy to go there. But, again, are we getting database protection or not? And of course, the bill doesn't say that we're changing this in relation to compilations because we are going to now introduce database protection. Nothing like that. And of course, it speaks about there'll be no protection for the contents of a compilation, which is a nonsense. So let me illustrate why I say it's a nonsense. So I'm sure some of you probably still read poetry, but I don't. But back in the day, we used to have these anthologies of poetry, right? So poems by various poets. Is that a compilation? Probably. Are you now telling me that those individual poems are no longer protected by copyright? Clearly that can't be the case. But that's what the proposal potentially means. What they probably meant to say that facts are not protected as part of a database. But that's already the case in copyright law. You don't have to go there. Works owned or funded by the state now belong to the state. Now, when is a work funded by the state? No clarification on this issue. So, for example, I work at a university. Is what I do funded by the state? We already have an act dealing with publicly funded research. How does this link with that act? Because at the moment, you know, basically, in terms of my contract with the university owns my intellectual property law. Do we want to change that? Does the government want to put up a bureaucracy that deals now with copyright throughout the country and take it away from universities? And these are the questions that this type of thing raises. When it comes to needle time royalties, again, fundamentally ill-conceived, no appreciation for reality. It wants to change us again from what we have, which is a liability rule in effect. It wants to bring in a property rule. And what I mean by that is that these are sound recordings, music, right? So that's what radio stations play, music. And artists and owners of sound recordings generally sign up with a collecting society that collects the royalties on their behalf. So what typically happens is a radio station plays a song, the collecting society, they have to submit their playlists to the collecting society will work out the royalty payable, and the radio station must pay. That's the sensible way to go about this. Of course, what the proposal says is no. The broadcaster must seek prior consent before playing any particular work. So you can't have a phone-in request show because you don't have the consent to play the song that the caller wants potentially. This is how ridiculous it is. The system isn't broken. Why go there? Can you see what we're dealing with here? So, I hope, and of course there's the issue of academic publications, but I'm out of time. I can speak about some of these issues. But it should be clear to any person who has a basic understanding of copyright law that the proposed legislation is a shoddy piece of work. If the consequences of the proposed legislation were not so serious, the DTI's latest attempt might have been a laughing matter. But that's all I have to say. Thanks.
Thank you very much, Professor. So we've got time for some questions. So would anyone like to kick us off? We've got about 20, 25 minutes before the coffee break. No comments at all. One from, could you just introduce yourself?
Yeah, sure.
Yeah, of course you can.
My name is Kwanji. I'm the CEO of the EPAS at the South African Innovative Pharmaceutical Association. Intellectual property, see now you've confused my head about where I work. Clearly there are a lot of sections that need a lot of work. Now, writing them, obviously, and commenting with loads of papers. Have you engaged the authors? I'm not sure who the author of this amendment is. To walk them through the process, because I think the writing and talk about the experience of what we've gone through with the first draft of the IP policy that was written by Mr. Mostert. It just takes much longer, I think, to write in loads of paper that for them to go through some of the issues that you've raised, almost need a discussion and making sure that is there an understanding of what the implications of what has been amended.
We've made overtures to DTI. Because I've been quite outspoken about it. I've written blog pieces, etc. It's been picked up elsewhere. So I've made overtures to DTI. You know, we're prepared to help. But our offers have been spurned. I was even phoned by somebody at DTI probably about a year ago, maybe more, promising that they would turn a corner and be more inclusive. Of course, I didn't hear again from that person. Of course, they just published this bill again. So no, the conduct hasn't changed. There's been it was under the Act, the Standing Advisory Committee on Intellectual Property Law has been non-functioning for, I think they tried to resuscitate it last year, but for something like 10 years, there was no Standing Advisory Committee. So existing structures have been allowed to sort of go into ruin. So I don't think there's a proper will to properly engage with the role players. And here I must say, the intellectual property fraternity, the law firms, are not like the sort of corporate company law firms. They will get on board if you call them for assistance. I've worked with them closely, and trust me, those people who feel strongly about intellectual property law will give off their time if DTI only showed them interest and you know, an indication that they would take on board what they have to say. But by and large, DTI has shut itself off, like I say, promoting some sort of ideological interest. Or from what I see, that's what it comes across, playing to the galleries, without having people there with the necessary expertise to actually press them on the consequences and impact of their proposals. You need to be challenged in your views. Like I say, the world doesn't need to be shaped in my image. I'm happy for a debate to take place, and then somebody with competence to draft the legislation. You know, even the vilest ideologies can be put down into well-drafted legislation. We had things like the Group Areas Act, but it was executed with legal skill and technical ability. So that you can't fault them on the drafting. What you can fault them on is the principle of the matter. Here, we don't even have an indication of technical competence. And that is really worrying. That is what we're dealing with. Yeah, it's coming.
Thanks very much, Prof Sadulla, for your insightful presentation. My name is Temba Nolichunga at the Free Market Foundation. It is quite clear from your presentation that the department is very lacking on two fronts. That is the drafting, technical drafting, and also in terms of the intellectual sort of content, you know, which would reflect the understanding as to what is at issue when it comes to intellectual property rights, so to speak. Now, you also mentioned that you have not been getting anywhere with the identified individuals within the department. Now, I have a suggestion, a proposal in fact, to be considered not now, because this proposal assumes that at the end of the day, everyone around here, or generally most of us, you might find that what you have said resonates with them. So my suggestion is that we put this at the back of our minds and consider it later on. This is a proposal. And that is, assuming that there is right now, without everyone commenting on the presentation, assuming that there is an appreciable degree of consensus around the most salient issues that you have raised, what might be considered is that there be a proposal generated, crafted, that everyone generally might embrace or to some degree find acceptable. Now, and then that proposal at the end of this exercise, meaning this meeting, could be sent out to everybody to see if they still would like to comment on that. Once at the end of the day, at the end of that exercise, there is now a firm proposal that's been distilled on the basis of your input and people's comments around here. Then that gets sent to the department, to the DTI. And now, the good thing about that would be that it would not be just one person or one department from some university or something like that, it would be a whole lot of people that felt very strongly in terms of what was being proposed, what is contemplated by the Department of Trade and Industry. So that's my suggestion, not necessarily for discussion now, but for us to keep it at the back of our minds and perhaps to be revisited if we feel that things are going generally towards a consensus-driven sort of sentiment. Thank you.
Just on that issue, like I say, the problem is, and this is the thing, how do we coordinate? That's what it comes down to. How do we coordinate and send a clear message to DTI about this? The problem is these short periods for comment. It has to be in next week, 17th, right? When is that? 17th, it's just over 10 days' time. Like I say, I've written sort of 11,000 words. It's probably going to go to about 15,000 words. The law firms, I can bet you, I see Adams and Adams here, Spoor and Fisher, they're probably getting some people to write in their firms because you're forced to actually just batten down the hatches and start writing because they don't give you time, 3 months or whatever, to coordinate and present a united front. By putting you under these time constraints, like I say, they want to railroad legislation through. And maybe, you know, this is something I've expressed in a parliamentary portfolio committee, and no one disagreed with me. So I still think my hypothesis holds. And incidentally, about engaging DTI and getting on board, I've offered to serve on the Standing Advisory Committee. Put in my CV, you know, filled in the forms, etc. Of course, never heard from them again. So I've made my fair share of efforts to offer my services. The point I made and legislation generally, the problem we have is that, and I suspect this, and this is my hypothesis, like I say, no one has disabused me that I'm sort of totally barking mad. I get the feeling that government departments like DTI have adopted sort of incentive mechanisms where people are incentivized through KPIs and, you know, other sort of management speak to update copyright legislation. So that person's bonus depends on getting legislation passed. And come hell or high water, and because you have an ANC majority, you can get anything through Parliament if you have enough friends. Even ill-considered legislation. Particularly if you're driving it to get your bonus. And I want to know if that is in fact the case. Because legislation shouldn't be drafted on that basis, and people shouldn't be incentivized on that basis. Legislation should be properly considered with proper input.
Oh, okay. Given everything that you've said and looking at the fact that you probably want to rewrite this, it's not going to be a comment, what is the likelihood of DTI or the government for doing anything about the comments that they will receive? Is there any possibility that they will review the draft and consider all your comments in?
Well, one hopes that they'll take on board the comments, and trust me, it won't only come from me. It will come from the law firms and other key stakeholders like publishers. But you get the impression that they don't really take on board the comments. And you know, this is based on past experience. What I didn't say is that this follows a 2015 bill, a copyright amendment bill. So we've been here 2 years ago. And there's no indication of improvement.
Any different route?
I don't know, other than standing on a public stage here and hurling abuse. I don't know. Because that's, you know, what it's come down to. Like I say, I've offered my assistants. I'm, in a sense, a bit of a state servant. You know, I work at a university. And like I say, I know the IP fraternity. They will come on board. And they, like I say, there used to be a standing advisory committee which was staffed by partners and senior partners of the IP firms. And it's been defunct for the better part of 10 years, if I'm not mistaken. I don't know, David and... Yeah. You know.
Sorry, Brian Scallon, I'm with the firm of management consultants. My question is, what are the implications of this legislation, because Bill Philip passed this legislation, for our international trade relations? Because it seems to me that what this legislation will enable people to do is to steal the intellectual property of other people. Take, for example, printing of a textbook, say a highly technical textbook. Let's think of something that we might need, say...
Engineering, yeah.
How to design a nuclear reactor.
Yeah.
It might be something.
Just off the top of your head.
Now, this could be coming, it could be printed locally, stealing the copyright of the engineers who wrote it in the United States or wherever. And this would surely have implications for our international trade relations. And would this be the case, and could you comment on that?
Well, you know, the good thing about, well, the strange thing about intellectual property law is that it's harmonized to a large extent across the world because of international conventions. And you have the Berne Convention on Copyright, and there's the TRIPS. So you're right. I mean, I don't know to what extent a particular country will consider it significant enough to take the matter to the WTO. But I think we are in breach of our obligations, yeah, like TRIPS. I think these provisions are overly broad and, like I say, within the logic of the bill itself, unnecessary. You know, if you say that you can get a compatible textbook at a reasonable price, why don't you get that textbook? Why ride roughshod over my textbook? Your own logic says that you shouldn't be doing that. So, you know, it's a concern, a real concern for, and, you know, the international harmonization means that copyright works from elsewhere are automatically protected in South Africa. Right? So if a foreign author's works and copyright owner's works are wholesalely infringed in South Africa, I think they could rightly take the case to their particular government representative and say, well, blacklist South Africa.
Which could have enormous economic implications for defeating the original purpose.
That's right. Like I say, I mean, and we're dealing with, like I say, publishers who bite government's hand off for a contract. You know, they are dying to get government contracts because it means hundreds of thousands of books. Why aren't you signing those deals? Or, like I said, if you think you want to donate works to the public domain, it's not going to cost you that much to pay an author, group of academics, to write a set of textbooks, which then you can distribute to your heart's content. Why ride off the backs of commercial publishers? And, you know, when it comes to academic publishing, there's this proposal now that basically journal articles that we write, that we publish in journals, must be made freely available within a year of publication. That's a shocking one, because say we have the Stellenbosch Law Review at Stellenbosch. We sort of started that, but that is produced in collaboration with Juters. We've signed an agreement with Juters. Now, Juters does all the typesetting and printing and all that. There's a good reason why we don't do it in-house. We don't have the expertise. We don't want to skill up and build up resources in that department. We only produce one journal as the law faculty, right? If government wants to put its money where its mouth is, well and good. Give us a truckload of money to do that journal in-house, and we'll make it openly available from day one. You can't have your cake and eat it. There's no such thing as a free lunch. That's the point that I want to make. And the government's proposal might be that now tutors might come to us say, listen, this is not economically viable for us anymore. If we're forced to make our content available within a year, why are we in this game? We don't want to do academic journals. You know, it doesn't make sense to us. It doesn't make our book stick. What will happen then? Where do I publish? Probably a foreign journal. And then you get a story of Europeans ripping off poor Africans. Right? Because our own journals have collapsed. Or that we can only produce academic publications of a poor quality, not properly edited, you know, not properly published. So, you know, you must think about the consequences. Fund universities properly. Let them do the, you know, all their publications in-house. And then you can maybe get away with nonsense like that. But that's only damaging.
Professor, I'm not very knowledgeable about this particular industry, but I'm from the Free Market Foundation, my name is Terry Markman. It seems to me that, I listened to a few comments and yours in particular, that the arguments you put across are extremely sound. So we're not looking for an intellectual input into how to argue against what they do. It seems, and I think Kemba touched on this, it seems what we're looking for now is really a campaign. We've got all the intellectual experts that we need to put across the arguments how bad this legislation is. Now you've got to get it out there in the public domain and keep on and on and on at it. The first big question is, can you get an extension past December 2? Because if you can't, you're in a lot of trouble. If you can, then there are a whole lot of things that you can do. You've got to go and talk to the media, you've got to go and talk to the parliamentary portfolio committee, and keep the pressure on them, but consistently. And if I can say so, the Free Market Foundation is fairly good at doing this. And I haven't had a chance to speak to my colleague Jason, who's involved in this, but are we doing anything in this regard? Yeah. So I think that maybe at tea time or lunchtime, something like that, a few people need to get down and decide, do we have resources to put together a campaign for this? And I'm not being, I haven't been involved in some of these campaigns, but I'm sitting on the outside opinion. We have very, very good experience on this, on how to get these ideas across. It's clear to me that with people like you and the other people in the room, the problem is not getting the intellectual information. I think we would win that if we went to a court. We've now got to fight the other battle, which I was for a campaign.
No, that's the thing. How do we get our message out there? And like I say, we publish our comments online and on our blog once we've submitted it to DTI, but maybe we should put up a collective sort of endorsed set of comments. But
it's not one set.
no.
It's non-stop. These guys are, and you are happy with that, we pay lots of money to write this nonsense, are writing non-stop.
That's right.
You've lecturing, you've got a group of people there who are on, you've got to get a campaign that hits them all the time.
No, and this is the point. It is this type of incompetence results in a colossal waste of human resources. Because like I say, I'm writing for a week, Adams and Adams are writing, Spoor and Fisher are writing, publishers are writing. We shouldn't have to waste valuable resources putting out fires started by DTI, which we constantly are required to do because of, like I say, the ill-considered proposals. So it's a massive waste of human resources. I mean, I just did a back of the envelope calculation. If I were working at Spoor and Fisher or something, writing comments for a week, it would have been over 200,000 rands worth of billable time, easily. $250,000 probably. So that is a huge waste of human resources. Unnecessarily wasted because somebody couldn't be bothered to appoint somebody to do a proper job. And you have then multiple numbers of people now having to tell that person what a shoddy job was, or piece of work was produced. That's really not an efficient way to go about things.
I just wanted to put a positive spin to this. We've gone through this in health recently, the IP bill published, if you remember, in 2013. And the comments that came from that draft were just as upsetting and annoyed as this. And that was thrown into the bin somewhere. And now we have a IP consultative framework, and I really am not speaking of health in detail. I think it's one process that we've really found very positive and very engaging. So let's hope that even this will not see the end of the day, this copyright amendment, and that someone within the department, and obviously to them from the minister's office to realize that there's just so much fury out there about the mess that was there with the original draft policy. And it was thrown out and taken to a different division, to a different person who has an understanding of this, and it's written very, very differently. So I'm just saying, let's hope that.
No, I hope your sort of optimism is not misplaced, and this thing never sees the light of day. But you know, again, it's why do we have to go through this sort of exercise at all? It is not in the country's interest. You know, when somebody elsewhere picks up this legislation, it creates a bad impression on our country. It suggests that, you know, we're some sort of banana republic, that we can't even get people to write sensible legislation. This is a bad advertisement for the country. We shouldn't even put out stuff like this. It really puts us in a bad light. And we have the expertise in South Africa. We shouldn't be embarrassing ourselves in this manner. And you know, I've sent an email to the relevant portfolio committee person to appear on the 27th. They've already scheduled dates, 27th, 28th, and 29th. Of course, I'm still waiting to hear from that person. So I leave no stone unturned to, you know, get on my soapbox and have my say about what it is in the effort to, like I say, stop this seeing the light of day. But other efforts have come to naught. So, for example, the Intellectual Property Law Amendment Act, which was rushed through in December 2013. Fortunately, it hasn't been brought into effect yet. But this bill suggests that, like I say, they haven't shelved that possibility, which is a real concern. So they don't want to backtrack on mistakes. You know, come hell or high water, like I say, I don't know if it's a personality issue or a person doesn't want to concede that they were wrong in the past, but it could do untold damage to the structure and integrity of our law. But like I say, if personalities are bigger than the country, that's what we're faced with.
One final question, then we'll
Sorry,
break.
just this one. I'll try to be brief. Now, in terms of the very basic sort of strategy proposal that I was submitting for consideration later on, and interrogate more input, we might consider, because there is so much at stake in terms of proposed legislation, so much at stake that it would run across the entire economy, it would reverberate across the entire economy in terms of the unintended bad consequences of this. And so that might inform the sort of strategy this is where we stand, this is what you need to defend, this is what you need to put across, this is how you go about arguing this and so on. So it would be an exercise in terms of disseminating intellectual ammunition to all the others. So it's not only just the DTI, the Trade Industry Portfolio Committee, that is focused on. And I hope they might find themselves in this position where they see that, oh, everybody sees that everybody has no those now. You know, and might start to be, say, maybe receptive to critical engagement by, say, the likes of people of your caliber, for example, and many others. But again, this would be for consideration later on, assuming that there might be an appreciable degree of consensus around the salient issues that we raise. Thanks.
Thanks.
Thank you, Sandra. So thank you very much, Professor, for your illuminating.